Pam Bondi did not expect the room to shift against her so quickly. But the moment she began answering, it was obvious something had gone off script. Her tone sharpened. Her response stretched longer than necessary. The confidence she walked in with started to fracture as she tried to explain an answer she clearly didn't want to say directly. For viewers watching later, the moment would be described as tense, awkward, even uncomfortable. But inside the room, it felt more serious than that. It felt like something wasn't right. What made the moment so striking was how simple the question actually was. It wasn't aggressive. It wasn't partisan. It wasn't complicated. It required a clear yes or no, followed by a plan. And yet, Bondi struggled to land anywhere near a direct response. That hesitation is where everything began to unravel. Representative Joe Morelle had barely finished speaking before the discomfort became visible. His question focused on federal prosecutorial resources and whether they were being used effectively to address threats against members of Congress, especially in light of the recent tragedy in Minnesota. He cited alarming numbers. In 2024 alone, the U.S. Capitol Police identified nearly 9,500 threatening or concerning statements aimed at lawmakers. Despite that, federal prosecutors had secured only 8 convictions. With threats escalating, he asked whether the Department of Justice would commit to assigning at least one assistant U.S. attorney or special assistant U.S. attorney at least part-time in each of the 94 federal districts to investigate and prosecute threats against members of Congress. It was a direct question, and it demanded a direct commitment. Bondi began by acknowledging the seriousness of the issue. She called the Minnesota incident horrific and said she had spoken with Minnesota Attorney General Keith Ellison and Senator Amy Klobuchar. She confirmed that federal authorities were involved, including the FBI and U.S. attorneys, but instead of answering the question, she pivoted. She explained that many cases are handled district by district and that her National Security Division is involved broadly. She emphasized that meetings happen every morning, that discussions are ongoing, and that coordination is taking place. Then she shifted again. She brought up Pennsylvania Governor Josh Shapiro, noting that she had spoken with him as well and that federal and state prosecutors were working together there too. She stressed cooperation, repeating that political party doesn't matter when violence occurs. She emphasized safety. She emphasized communication. She emphasized process, but she still hadn't answered the question. Only after circling the issue multiple times did she finally say something closer to a response. She agreed, in principle, that assigning at least part-time prosecutors in each district would be appropriate. Then she immediately softened it, saying the work was already being handled through the National Security Division and that she would be willing to discuss details later in a secure setting. It was a lot of words, but very little clarity. The exchange ended politely. The chairman moved on, but the moment lingered. Because what the committee and the public had just witnessed was not a firm commitment. It was hesitation wrapped in reassurances. And in a moment defined by rising threats and real violence, that hesitation spoke louder than any prepared talking point. The question sounded technical, but the implications were enormous. The focus was on what happens after January 6th, not just politically, but legally. Specifically, lawmakers wanted clarity on whether presidential pardons tied to January 6th could be stretched to cover entirely separate crimes discovered months later. Crimes like illegal firearm possession found during unrelated searches long after the Capitol attack. That's when the pressure started. The question was straightforward. Several individuals who received presidential pardons for January 6th related offenses were now arguing in court that those pardons also protected them from prosecution for crimes uncovered later, in different states, under different circumstances. The lawmaker wasn't asking about who holds the pardon power. That part is clear. The Constitution gives that authority to the president. What he was asking was far more basic. As the nation's chief law enforcement officer, what is your legal view on the limits of those pardons? Bondi didn't answer. Instead, she immediately deflected. She said the pardon power belongs to the president, not the Department of Justice. She said the issue was pending litigation. She said she couldn't comment. But that wasn't what she was being asked. No one was challenging presidential authority. No one was asking her to rule on a specific case. So the lawmaker pressed again. He even cited the Department of Justice's own written position from February, which clearly explains that a pardon does not erase guilt or overturn a conviction. It simply removes punishment for a specific crime already committed. A pardon is not a blank check. It does not automatically shield someone from unrelated offenses committed at a different time. So again, the question was repeated. Do pardons for January 6th cover crimes unrelated to January 6th? Once again, Bondi avoided answering. This time, she pivoted entirely. She brought up Joe Biden. She brought up Hunter Biden. She referenced death row commutations. She jumped between topics that had nothing to do with the question on the table. It was a diversion so obvious it barely disguised itself. And the more she talked, the clearer it became that she was deliberately refusing to state what the law actually says. The lawmaker pushed back. Visibly frustrated now, he reminded her that she was not sworn to protect any president. She was sworn to uphold the Constitution. As Attorney General, she has an obligation to interpret and explain the law, even when the answer is politically inconvenient. He wasn't asking her to comment on Democrats or Republicans. He wasn't asking her to criticize a pardon. He was asking for a legal boundary. Does a pardon cover unrelated crimes or not? Still, no answer. Instead, Bondi claimed she couldn't discuss anything that might intersect with litigation. At that point, the exchange stopped being technical and became confrontational. The lawmaker called it out directly, accusing her of filibustering. He said this was a serious issue, one that affects the integrity of the justice system. Dodging it, he argued, was not caution. It was avoidance, and then he yielded his time. What made the moment so striking wasn't just the refusal to answer. It was how unnecessary the refusal was. Every modern attorney general has explained the limits of presidential pardons. It's not controversial. It's settled law. Yet Bondi treated the question like a trap. She had no escape from and that revealed the truth of the moment. This wasn't just a legal question. It was a test of independence. A test of whether the Department of Justice still operates based on law rather than loyalty. And Bondi failed it almost immediately. The more she stalled, the clearer it became. The answer wasn't unclear. It was just inconvenient. Morelle didn't open with opinions or hypotheticals. He started with what is already happening inside courtrooms right now. Judges across the country are hearing arguments. From January 6th related, defendants who received presidential pardons and are now claiming those pardons protect them from entirely separate crimes. Committed months later, one of the clearest examples involves illegal firearms. Discovered in California long after January 6th, the claim being made is extraordinary, that a pardon for past conduct somehow erases responsibility for future offenses. Not just what happened that day, but anything that came afterward. That was the context, and the question that followed could not have been simpler. Morelle wasn't asking Bondi to rule on a case. He wasn't asking her to revisit January 6th. He wasn't asking her to critique the president's power to pardon. He was asking about a basic rule of law. Can a pardon for a past act shield someone from crimes committed later, unrelated to that act? That's it. This isn't a gray area. It's not unsettled doctrine. Every first-year law student learns this distinction early on. The Department of Justice itself put it in writing earlier this year. A pardon removes punishment for a crime already committed. It does not erase facts. It does not nullify convictions. And it absolutely does not function as a license to commit new crimes in the future. But the moment that question was put on the table, Bondi veered away from it. Instead of answering yes or no, she pivoted to presidential authority. She talked about how the pardon power belongs to the president. She referenced pending litigation. All of that may be true, but none of it addressed what she was being asked. It was a textbook deflection language that sounds official, while carefully avoiding the point. So, Morelle asked again. Calmly, precisely, he restated the DOJ's own position. A pardon is an act of mercy for something that already happened. It does not extend forward in time. It does not grant permanent immunity. It does not cover unrelated crimes committed later. Then he repeated the question. Does a pardon for one event cover crimes that happen afterward and have nothing to do with that event? That's when the exchange unraveled. Bondi didn't clarify. She didn't qualify. She didn't explain nuance. She abruptly dragged in Hunter Biden an issue no one had mentioned, no one had asked about, and which had nothing to do with the legal question at hand. She jumped to commutations. She referenced unrelated cases. She changed subjects entirely. It wasn't subtle. It was the reaction of someone who needed to escape the question, not answer it for a moment. It stopped feeling like a congressional hearing and started feeling like a deliberate attempt to steer away from an unavoidable conclusion. Like watching someone grab the wheel and swerve, not because the road was unclear, but because what lay straight ahead was too dangerous to confront. But Morelle didn't let it slide, because this wasn't about politics. It wasn't about parties. It wasn't about January 6th optics. It was about whether the Department of Justice is willing to say out loud what the law already says on paper, and Bondi's refusal to do that spoke louder than any answer she could have given. Morelle pulled her back instantly. His tone stayed calm. His voice didn't rise. He didn't show anger or frustration. Instead, he did something far more effective. He clarified the question one more time. "I'm not asking who has the power to grant a pardon," he said plainly. "I'm asking about the legal limits of what a pardon actually covers." That clarification changed the energy in the room. It was the kind of moment where everyone understands the situation at once. Not because something dramatic happened, but because the truth suddenly became obvious. Bondi wasn't confused. She wasn't misunderstanding the question. She wasn't lost in legal nuance. She knew exactly what she was being asked, and she was deliberately refusing to answer it. That's when everything started to unravel. She tried to pivot again. And then again. She brought up political figures. She referenced unrelated cases. She dragged in past events that had nothing to do with the narrow legal issue in front of her. Each sentence sounded more like an escape attempt than an explanation. It was like watching someone talk in circles while the space around them keeps shrinking. And with every deflection, it became clearer why she was avoiding the answer. She did not want to say on the record that a presidential pardon does not cover future crimes. That silence triggered immediate reaction outside the room. Online commentators picked up on it instantly. Because for months there had already been quiet discussion in legal and political circles about this exact issue. Admitting the limits of those pardons would directly undercut the arguments some defendants are currently making in court. And more importantly, it would clash with the broader messaging coming from the administration that these pardons wiped the slate completely clean. Saying the truth out loud would fracture that narrative. So, instead of taking a position, she chose avoidance, and that's when Morelle cut through it. He didn't soften his words. He didn't dress them up. He called it exactly what it was: filibustering. A term rarely used directly, face-to-face in a moment like this. And when he said it, the effect was immediate. The room tightened. The air shifted. Because calling out a filibuster in real time doesn't just expose the tactic, it exposes the reason behind it. Bondi's body language changed. Her posture stiffened. Her voice narrowed. Because once the tactic is named, the motive becomes impossible to ignore. Morelle reminded her of something fundamental. She did not swear an oath to protect a president. She did not swear an oath to defend a political strategy. She swore an oath to the Constitution. His frustration wasn't partisan. It was constitutional. The idea that the Attorney General of the United States could not or would not clearly explain the basic limits of a presidential pardon stunned the room. This wasn't about any specific defendant. It wasn't about January 6th. It wasn't about politics at all. It was about a core principle of the legal system. Because here's the reality that made the moment so uncomfortable. If a pardon can cover future crimes, then there are no boundaries. If it stretches beyond the act it was issued for, accountability collapses. If a pardon becomes permanent immunity, the rule of law stops functioning. and that is the danger Morelle was pointing to, not subtly, not hypothetically, but directly, because once justice becomes optional, the system itself starts to break. Without clear limits, the danger becomes obvious. A president could theoretically hand out permanent immunity, creating a protected inner circle, people free to act without fear of consequences. Legal scholars have warned about this scenario quietly for years. But after this hearing, that warning was no longer quiet. Bondi's refusal to say the words didn't calm concerns. It amplified them. Silence is not neutral. Silence communicates. And in this case, it communicated exactly what she did not want to acknowledge out loud. The administration's position on these pardons is far more fragile than it appears. The legal ground beneath it is thin, and one clear statement could crack it wide open. As the hearing drew to a close, the mood shifted again. Morelle wasn't angry. He wasn't grandstanding. He was visibly disappointed, almost stunned. He said it plainly. Her refusal to answer was demeaning to her responsibilities. And that wasn't political theater. It was an assessment, because when the Attorney General of the United States cannot explain a basic legal principle, the system itself starts to wobble. That's what people reacted to when the clips began circulating. It wasn't her tone. It wasn't her detours. It wasn't even the political deflections. It was the unmistakable reality that when confronted with a foundational truth of the law, she shut down. Not because the answer was unclear, but because saying it would expose something the administration wanted to keep deliberately vague. And this is the part viewers kept replaying. She wasn't being asked to justify past actions. She wasn't being asked to take a partisan position. She wasn't being asked to rule on a case. She was asked to confirm what every attorney general before her has openly stated. A pardon does not protect someone from future crimes. She wouldn't say it, and that refusal speaks louder than any answer she could have given. It leaves the public with an unavoidable question. If the law is that clear, why wouldn't she say it? And if she couldn't say it, what exactly is being protected? Those aren't partisan questions. They're constitutional ones, and the silence we witness tells its own story, a story about pressure, hesitation, political vulnerability, and the uncomfortable possibility that honest legal clarity now conflicts with the narrative being defended above her. When the hearing ended, there were no answers, no resolution, no clarification, just a lingering unease and a moment that revealed far more than it resolved, because sometimes, especially in politics, the refusal to answer is the answer. If you want more deep dive breakdowns of moments like this, where the truth slips through the gaps in reactions, reveal more than words, make sure to subscribe, hit like, and turn on notifications so you don't miss what comes next.